All right, welcome back. It's now 24 minutes after 8 and we're into the last leg or the last lap of this particular program today. Now, on Black and White today, we'd like to talk about matters succession. And family feuds, it comes to inheritance matters, is not a new thing in this country. For a long time, the rich and mighty have been engaged in ugly legal succession battles over sharing what estate has been left behind by the deceased. Just last month, the family of former Vice President, the late Wamalwa Kijana, was in the media feuding over the estate, with one faction complaining of getting a raw deal. This then brings into focus the issue of wills, and have Kenyans embraced the concept of writing a will? What does it take for one to write a will, and how does that secure you? How does one safeguard that there's no interference, and why wills are still challenged in court? We interrogate all these on our Black and White segment this morning with Caroline Kamau from FIDA. But first, let's take a look at what Wamalwa's family feud was all about.
That after passing of our father on the 23rd of August 2003, I was appointed together with my stepmother, the late Yvonne Nambia Wamalwa, as joint administrators of the estate. That until her death on the 25th January 2018, we have been administering the estate together with Yvonne Wamalwa on behalf of the 5 children of the late, who are the legal beneficiaries of the late VP. And we were surprised to see through the media yesterday a statement by Mr. Derek Mboya touching on matters relating to our late father's estate, to which he is a stranger, as he is neither a beneficiary nor an authorized person to speak on our behalf. That the matter being alive before the court is sub judice, and we are arguing all and sundry to keep off and let the court determine the matter in accordance with the Constitution and the laws of Kenya. That this matter is coming up for hearing on the 4th of February, and we believe the court will determine the rights and fair share of each beneficiary of the estate.
All right, and that was part of the statement that was read. And now joining me is Caroline Kamau, a lawyer with FIDA. Thank you for joining us this morning. Now, this is a common thing that we have seen happen, you know, particularly families that have large estates. Feuding and fighting over property after the deceased who owned the property or who was the custodian of the estate has passed away. Is a will a guaranteed way of ensuring that this does not happen?
Yes, a will would be a good start because it ensures that the person, the deceased during his lifetime, is able to have a proper sort of say in terms of how his property devolves to his beneficiaries and to his family, to dependents, because dependents do not necessarily have to be family members. Some dependents can be, for example, you take up a child and you're treating them as your own child. You take a parental responsibility over them. So a will ensures that you basically distribute your estate while you're alive the way you want it to be done. Yeah.
We'll come into the details of how you actually write a will, but when we see a situation like this we've just played there was a will that was in place but was still being challenged in court. Then there are people that come in and it is possible to challenge a will.
Yes.
Okay, so what are the circumstances that surround one challenging a will?
So the circumstances mostly that we see now in our courts challenging the wills are to do with especially fraud. And a lot of the allegations are that either the person did not sign, or even if they signed, they were not, they didn't have the proper mental faculties to know exactly what it is they were signing. For example, the person was bedridden, and so they were just given a blank document and told, sign here. Sign here. And so they really didn't understand the content of the document that they were signing, and so you'll have family members coming to say, no, at the point that this person was signing this document, or on the date it is alleged they signed the document, this person was too sick, or this person was not really coherent enough to know what exactly it is that they were signing. And we also have seen cases whereby you have family members alleging that actually someone assisted the testator, who is the person who writes the will. They assisted them either by holding their hand or holding the pen and then assisting them to do the writing. And so those are some of the scenarios where you find the wills are being challenged. Yeah.
Is it possible for one to challenge a will by virtue of the fact that maybe you feel disinherited, or you feel that you are not given an equal measure compared to the rest?
Yes. When it comes to challenging of wills, there is no sort of, it's not closed, that you cannot challenge a will. Even a will whereby everyone was given something, you can still go to court and say, whatever I was given was not, I don't feel it is enough, or I want more. And then the court now will, at the point that the court is looking at the will and determining whether or not the will was properly and it's valid, then at that point, then you're able then to produce evidence that shows why it is you should be given more than maybe your siblings. Yes.
And now in a case like that, then one might ask the question, what is the point of the will? Because then I would imagine the will is something that the testator is writing of what they would want their estate to be when they're not there.
Yes.
In other words, even if they were alive, this is exactly how I would execute whatever that I would want to do. So my will is speaking on my behalf. But now if it is challenged, you're challenging me, as it were.
But we have to understand that having a will does not mean that it cannot be challenged. Having a will, it's a person saying my wishes after I am gone are to distribute my estate in a certain way. That then does not preclude your family members from saying, I feel that I was shortchanged. So the law doesn't preclude them that after the testator is gone, that now, I mean, his will stays the way it is. If someone feels aggrieved, and that's why we have the law, if you feel aggrieved, you approach the courts, and the courts will listen to the matter and listen to why it is that you're feeling aggrieved by this will, and then determine based on evidence whether or not the will is valid.
Okay, and in a case now where it is challenged, on what grounds would the court challenge what the will or the testator wrote by virtue of the fact that that is already, should be final? He signed on it, assuming that they were of, sound mind.
Yes. So there, probably then we would have to go to what it is that is required by law for a will to be valid, and even for now the courts to uphold the will as is. So when a person is writing their will, we have two types. So you can either do an oral will or a written will. In most cases, the better way of going about it would be to do the written will. When you're doing a written will and it is in a written format, so for example, when it comes to the signature, by law, it is required your signature must show that you intended to sign this document.
How does that?
It's not, you are not scribbling, or it's not one of those things that probably you didn't intend to put your mark, for example, for those persons who cannot sign, and so they affix their thumbprints. So it needs to, by just looking at the document, a person needs to know or to see that this person actually, even how they've signed it, how they put their mark on the document, they intended to affix their signature or to put their thumbprint. Again, when it comes to writing a will, you have to have two or more persons witness the will. That is what now gives veracity to this will being valid. And the two or more persons can be even a beneficiary of your estate, can be a witness, but then there have to be two other persons who are independent, who cannot benefit from the estate, who really have nothing to do with the estate. Also, you can have your executor. Or administrator, per se, of the will, who can also be a person who witnesses, but again, you must have two other independent people. So for a will to be valid, it has to be written, it has to be witnessed, and when we are looking at the signature or the thumbprint, it must show that this person really intended to sign this document, that they had understood. So it's one of those requirements. So when a court is assured that all these requirements were met, then chances of the court invalidating the will become extremely small.
Does a lawyer qualify, the lawyer who is maybe in charge of that particular will, does he qualify as a witness?
Yes.
He qualifies?
Yes.
So you can have one of the beneficiaries plus another two?
Yes, another two, and they need to be independent people who really have nothing to do with your estate. They are not going to benefit from it. So, yes.
Okay. In a case where a beneficiary is not part of the witness, they're not part of that witness team, is it possible for a lawyer to take advantage at the point where the deceased is there to alter?
Now, when it comes to alterations, and those are some of the areas where you find families do challenge the validity of the will, because, for example, when you just look at the document at face value, you see maybe there was an alteration by hand. Maybe it's a printed document, but then there's a handwritten either crossing or addition and things like that. So at that point, then one can challenge to say, okay, who wrote this? And if for example, a testator decides that they would like to alter their will, it's allowed by law. So you can alter a will by either doing a codicil, which is like another will. Maybe you just want to alter one paragraph, and then you'll attach that to the original written will. But then again, you find there are areas where when that alteration is made, it needs to be countersigned against, and the witnesses also need to countersign, because then it shows that the testator is the one who made the alteration, and there were two independent witnesses who witnessed the alteration being made, and they've countersigned it as well. Yeah.
All right. Is it possible for a lawyer to almost take away somebody's estate if they're not aware? Because some of the wills that are done in secret. And by secret, I mean the beneficiaries are not part of the will making. They're not even aware that there is a will. But at the point where the testator is deceased, is there a possibility of the lawyer, or is there a safeguard that that lawyer will not now basically just take away the will, or even not declare some property? Because some people have large estates. Not everything might be in the house, for example. Is it possible for a lawyer to take advantage and take off with that?
Of course, there is the chance that someone could become fraudulent, an advocate would become fraudulent, and so try and get something from the estate. And probably then the only safeguard for the family that becomes going to court to challenge if the lawyer has gotten maybe part of the estate at the point that they are doing succession proceedings, to challenge why it is that the advocate got a certain share of the estate.
But that would mean that the family would have to know that estate was there. If they did not know, then that could literally just disappear that way.
Yes, and that's one of the challenges that we are having, even as we receive clients at FIDA to do with succession matters, because you find most of the times a lot of people don't declare their estate or they don't declare their properties. And so at the point that the person dies, then the family that remain are the ones who now have that duty to literally go everywhere to sort of try and identify this property, what was the extent of the estate. And sometimes, yes, there are cases whereby you would find a widow really does not know the bank accounts that the husband had, or does not know if he had property. They probably just know it's somewhere in Nairobi, but they really don't have the specifics. And so those are the cases where you find it is challenging, and that's one of the reasons why we are encouraging more people that you need to be open with your family, or at least even one trusted family member, so that in the eventuality that you do pass on in an untimely death, then your family has an easier time of identifying what is the extent of your estate and where are your properties. Because otherwise, for example, things like shares, bank accounts, after a period of time, if no one comes to claim them, then they are taken up under the Unclaimed Financial Assets Authority, will take them up, and then, I mean, they have to revert back to government if no one really comes after that. Yeah.
And what's the period of those unclaimed things? What's the period that the government gives that nobody has claimed them, for them now to have them handed over to government? For one of the cases that we're handling, the assets have stayed unclaimed for a period of 6 years. And so automatically the bank notified us that they were now forwarding the monies to the unclaimed financial assets. And if the family should ever come for the property, that's the route they're supposed to go. To take, okay. All right. And your advice generally to anybody who wants to write a will, before we actually come to the actual writing of a will, what it takes is to declare everything that you have, and hopefully possibly involve your family, because there's some I've had who possibly may even fear death, early death, because their family members would want to take their estate earlier than before the deceased.
Yes, and that's the sort of unfortunate circumstance in which our society finds itself, because now you're finding it's really a balance between, do I declare my wealth and then my children are sort of going to kill me off in order to inherit faster or at an earlier date than what I would have intended. And so it's one of those things, but I believe for every person, there's at least one trusted person that you can involve at the point that you're intending to make a will.
Okay.
Yes.
All right, you've talked about two wills, oral and written. Let's start with the oral will. What's the procedure of doing an oral will?
So an oral will has two facets. There's an oral will for the everyday citizen, and then you have oral wills for our servicemen and women in the armed forces. So when it comes to our servicemen and women, they're required to make an oral will. And for it to be valid, at least there must be two witnesses who hear you saying
what you'd want.
how you would want your property to be divided. For servicemen and women in the armed forces, they need to, the time period, you must have passed on within 3 months of making the oral will. But for servicemen and women, if maybe you're in active deployment, then within that period of active deployment, if you die, then even if it was beyond the 3-month cutoff period, then your oral will still remains valid. But now for your everyday citizen, it's the oral will has to be, again, before 2 witnesses, and then also you have to die now within the period of 3 months. For the rest of us...
In short, it's only valid for that 3 months?
Yes.
After the 3 months?
After the 3 months, so there's no oral will.
Yeah.
Yes.
Okay.
So then, and that's why probably the drafters of our laws of succession then came up with the written will, because the written will then remains valid unless you revoke it or you alter it. So when now you... aside from the oral will, now with the written will, like I had said, you would need to have 2 or more independent witnesses. It has to be written. You have to affix your signature, thumbprint on the document, showing the intention to make the will. And one of the requirements with the law is that even your witnesses who are witnessing you as you sign or put your thumbprint on the document, the way they witness the document by signing, there's a paragraph that states that they have seen you sign the document, they have seen each other sign the document, and to the extent that you understood what it is that you were signing. It's sort of a validation that this process was completed.
It was completed.
Yes.
So it's not one of those documents where I sign, send it to so-and-so, they sign, send it to another witness, they sign, and assume that this needs to be done in the presence
all of us have to be together in one place, because the last paragraph of the wills, as a requirement of law, is that all of us saw each other sign. So if you comply with that, then chances of the will becoming invalidated because either you didn't understand or there were issues, and especially where you have independent witnesses, the chances of invalidating that will also become minimal.
And maybe just to digress a little bit, is that applicable to any signature that requires witnesses that they need to be present, or other transactions that require a witness's sign or signature can be done without them being present?
For wills, everyone has to be present. For other transactions, the law requires that, yes, for example, if it's a land transaction, if it's a sale agreement that you're signing, the law requires also the witnesses to be present, so that all of you sign the document at the same time. But in practice, you find that's not always what happens. And so that's why you always find there are a lot of court matters whereby a person comes to say, no, I'm not the one who signed, or at the time that I signed, this was a blank document. But also, even for written wills, we must remember that you must be mentally, you're a stable person and you have sound mind. Because for a person of unsound mind, unless the time where now the mental faculties have returned, that's the only time that they can make a will. Okay. So, and you have to be above 18, of course.
All right.
Yes.
Now, let's also reflect on the ruling that was given recently, and it had implications on customary law practices. Maybe just break it down for us, and this is in regards to succession, specifically for women. So with the case that, the ruling that was done in Nyeri, I think one of the things that perhaps a lot of people didn't understand, it's not that it's the first ruling of its kind. Actually, there has been sort of a continuous momentum towards this, and ensuring that women and men, in terms of succession and inheritance, that they are on equal footing. So we can even go back as far as the case of Rono versus Rono, where daughters, for the first time, this was pre the 2010 constitution, where daughters were allowed to inherit from their father's property. But then we have seen, after the constitution, you have the case of Rukunga in Meru, whereby a married daughter was allowed to inherit her father's property. Then now comes this Nyeri High Court environmental case that says that a married daughter can inherit. But if you look at our constitution, I think now the law on that is settled. There's really nothing new that we are bringing on board. It's just the courts are interpreting what is in the constitution. Because if you look at the constitution, for example, it talks about that customary law is allowed. However, if the customary law practice contravenes or goes against what is already provided in the Constitution, then to that extent, the customary practice or law
is null and void to that extent. And so then if you look at things like Article 27 on ensuring equality between men and women, in terms of you cannot discriminate on the basis of sex, you can't discriminate on the basis of marital status. If you look at Article 40 on the right to property, that says it's every person. So it doesn't designate that married women are separate or are excluded from every person. If you look at Article 60 that talks about when it comes to the land policy that we're implementing throughout the country, the government must ensure that there's gender parity and you cannot discriminate a person when it comes to matters of land. And so if you look at all these laws together with the laws on succession, together with our land laws, all children are to be treated equal. And so our laws don't really say when you're a married person, you cease to be a child of your father. So unfortunately, because the law, the language it is couched in says every person. So it doesn't really leave room to a parent or maybe dependents or family members after the person has died. The law does not allow you now to exercise that because this is a married person, then they cannot inherit. The way the law is, as of today, is that all children are equal. Married or not, that is not an issue. So then, like the case, really, it was not reinventing something new. It was simply restating the position of the law today.
Okay, now, in a case like that where, let's take a man who has boys and girls and would like to leave an inheritance for them, however, some are married. Does that mean that the estate has to be divided equally, or does he still have the power to decide who gets what and in what portions?
Now, that's where we have to balance it out. Because the law as it is, married or not married, everyone is equal.
Everyone is equal.
Yes. And so it means that if in the eventuality that this person dies and they have not given a will or they have not provided adequately for their relatives, then the estate falls into what we call intestate succession, which means there was no will, and therefore it's the court to listen to the family members. They will propose how to distribute the estate, but eventually the court will be guided by the law, which says equal sharing of the estate.
But does the testator have, if there is a will, do they have the power to distribute as they like? And
Yes.
It doesn't have to be equal?
Yes.
Okay. And would that be challenged in court?
It doesn't, just because the person has distributed the way they want, does not then, again, preclude the children from going to challenge it in court. But usually where you find, especially where, even in large estates where there is a will, you'll usually find that the parent has provided, in terms of for all the children, there are certain things that each one of them has gotten. And in most families, some of the ones that we have seen that have been successful, there's really no challenge to the will. Everyone is sort of okay with the distribution the way it was. Okay. So really it depends on the family relation, because at the end of the day, if everyone is settled even before the person dies, chances of them now being aggrieved after they've already even gotten the distribution while the person was alive become very minimal.
Okay.
Yeah.
Now, we'll need to wind up, and because of time, we cannot cover everything. But should somebody have an issue in terms of the distribution of wealth or inheritance or a will that they would like to challenge, where does one begin?
So when it comes to challenging a will, the first point is you have to have the will. Because without it, you really can't go to court. And what are you really challenging? So you need to have the will. And at least for most people, what they normally do, if they write a will, they'll deposit, and what they're encouraged to do. So you'll deposit a copy of it with the lawyer who made the will for you. Some of them deposit another copy with the bank and then keep another third copy with them. And so you'll need to get at least access to that. And so once you have the will, have an advocate go through it, see what are the provisions, so that then they're able to explain to you if there's something that is a bit legal, they're able to explain to you, so that then from that point they can also be able to explain how the distribution was done before then you get to the point of, I am not happy with how the distribution was done.
Okay.
Yeah.
All right, Caroline, we'll have to wind up right there. Caroline Kamau, who's a lawyer with FIDA, thank you very much for joining us this morning and just breaking it down on succession. It is now just about 12 minutes to 9 o'clock and time for us to say goodbye. And thank you for for watching Morning Express. We take this opportunity to wish you a good day and pray that you have a successful one. I'll just read a few tweets that have come through so far in the show. Remember, our question was whether you support the proposal that was being given by women in regards to the 2/3 gender